let me talk about the moratorium itself, though. You might think that the moratorium would be a way to advance the ball on how to fix this broken process. But the truth is, it's being used actually exactly the opposite way. The governor said, I'm putting a moratorium on executions, just the execution, just the cases that are ready to get to execution. There's only 2 so far in Pennsylvania, and there aren't hundreds of others waiting for them. But there are many cases that are stuck in the appeals process and that we're trying to get through. When the moratorium came out, the defense lawyers went to the federal court and said, oh, you should stop hearing these cases. You should stop working on them. You should stop litigating them. So instead of having cases that would be ready to go when and if the moratorium is lifted, we're going to be a year behind, 2 years behind, 5 years behind, however long the governor waits. And only at that point will we pick up again with those cases, because the Third Circuit, which overturned so many death penalties, has recently said, oh yes, Mr. Defense Lawyer, we'll put these cases into suspense and we'll do nothing with them while you go ahead with your study.
There are cases that are pending before the circuit that are capital cases that are continuing in the briefing and that are continuing to
Okay, so your point is it's not a blanket suspension.
Correct.
It's just, I see DA Eisenberg in the back shaking his head, no, it is a blanket, am I correct? Is it a blanket suspension, or just?
The language is general. The court issued an order saying, in light of the governor's moratorium, these cases will be placed in civil suspense. They haven't issued that in every case yet, but every case that has apparently been ripe for action, that has happened.